generally.
And it also includes exemptions under the Safe Drinking Water Act?
Yes, that's my understanding.
NEPA, it also includes exemptions under NEPA, which is the National Environmental Policy Act, correct?
I haven't heard that one, but...
You don't question it?
I don't question it.
And you don't question that it also enjoys exemptions from the Resource Conservation and Recovery Act?
That's correct. That's my understanding.
And the Emergency Planning and Community Right to Know law?
Yes, that's my understanding.
And the Comprehensive Environmental Responsibility, Compensation, and Liability Act, CERCLA? That's the Superfund law?
Yes.
And also exemptions under the Clean Air Act, correct?
Correct.
So you'll agree with me that despite what any state or federal regulations are, that municipalities maintain a role, and they exercise it through zoning in protecting public health, safety, and welfare.
Zoning amongst other regulations, yes.
There's a principle in zoning law that if there is an ambiguity in an ordinance, I think of it as a tie going to the runner.
Goes to the landowner, that's correct.
If there's an ambiguity in the ordinance about whether a land use is allowed, you read it in a way to allow the landowner to use the property. Correct?
The highest and best use.
There was actually a Commonwealth Court decision that just came down a couple weeks ago that reaffirmed that principle. Are you familiar with it?
No, I didn't see it.
So
But that's okay, but it's been long-standing.
Okay.
Ties go to the landowner. That's the question is whether there's an ambiguity.
Right. And you agree that that the zoning hearing board has a role in validity challenges brought by neighboring property owners of a property that's proposed to be developed under an ordinance, correct?
I agree that the MPC provides substantive validity challenge jurisdiction to the zoning board and to the governing body under certain circumstances.
And I think you've actually been involved in a case where a set of neighboring property owners brought a challenge to the use of, I think it was for a helicopter pad for a hospital facility. This is Klein versus Shadyside, a Shadyside entity. They brought the challenge to the validity of the ordinance in court, and you successfully argued that it belonged at the zoning hearing board, correct?
It was, but just to clarify, and I'm not disagreeing, the zoning board of adjustment has, it's not under the MPC. It was a question, where do you go when you don't have the MPC? So it doesn't really apply.
But it's parallel.
It is. It's parallel. Yes. The difference in that case is that the distinction I'm trying to, the problem that I have with the characterizations is what's lost in this entire case in chief that I can see is the Geyer well pad. There was a permit issued for it, and I believe, in my opinion, is that no matter what happens here, that's a valid permit.
You're talking about the DEP permit or the township permit?
No, the township permit. There's nothing here because, based on Mr. Fode's testimony, it would go back, even if this ordinance is invalid, it would go back to a permitted use. That well pad permit wouldn't be touched, it wouldn't be made invalid. So we're here basically on an advisory opinion. which is not what zoning boards are here to do.
Well, zoning hearing board can declare an ordinance invalid, correct? Correct?
The zoning boards hear validity challenges. They have jurisdiction over validity challenges, that's correct. This board cannot grant any relief that would impact that well pad permit, though.
You understand that when a validity challenge is brought, that part of what's being considered is all the issues you talked about earlier about balancing, about whether constitutional standards have been met, correct? Correct?
Generally, that's the nature of a validity challenge.
And if the determination is that those standards have not been met, and not just constitutional standards, but standards under the municipality's planning code, correct? That if those standards haven't been met, that the zoning ordinance can be declared invalid, correct?
It can, and in those instances where that ordinance was a permissive ordinance, which is what these challenges are all about and what all the cases deal with, then that landowner would not get the benefit of that permissive ordinance. That's not what's going on here. This is a restrictive, just a minute, this is a restrictive ordinance, and by eliminating the restrictions, you go back to an as of right, as determined by the township permit. So this is an advisory opinion that has no impact on the Geyer well pad.
You understand that the Geyer permit's being challenged here too, don't you?
I read your appeal, yes.
Well, there were two appeals. Did you read both?
I reviewed the challenger's notice of substantive validity challenge and zoning permit appeal.
You reviewed both?
That entire package. It was presented as a single package to me.
Okay.
Yes.
Your opinion about about the impact of any ruling is premised on your conclusion that the zoning ordinance, as it was written prior to Ordinance 127, allowed oil and gas development everywhere. Is that correct?
No, you're blending these actions, and I'm not going to blend them. We've been talking consistently about the validity challenge.
I'm asking about the validity challenge.
And there is nothing under that validity challenge. If you can prevail on the permit, the challenge to the permit, you prevail on the permit.
So I'm asking about the validity challenge. Your testimony on the validity challenge, that there could be no relief that the zoning hearing board could offer, is premised on your argument, your opinion rather, that the zoning ordinance as it existed prior to Ordinance 127 allowed oil and gas development everywhere. Is that correct?
That would be the determination that was made. That's where it would go. And then you would start, your starting point then would have nothing to do with a substantive validity challenge, would be a standard protest appeal challenging the determination. That's what this board should be hearing.
The conclusion, you're answering a different question than what I'm asking.
I'm not trying to, honestly. Okay. I'm trying to understand.
You've offered an opinion about what result, if any, the zoning hearing board could give.
No, on the validity challenge.
Yes, that's what I'm asking about,
yes.
Sir.
There are two causes.
Yes, there are.
Okay. So yes, on the validity challenge, there's no relief that they can grant.
I'm asking a question about that conclusion of yours, sir. Okay?
Yes. I'm trying to answer.
Okay. I'm just asking you to listen carefully.
Okay.
If you would, let him ask.
Yeah, absolutely. Absolutely. Ask it until I understand it.
Your opinion here is premised on the reading of the zoning ordinance prior to Ordinance 127, a reading that suggests that oil and gas development was allowed by right everywhere, correct? Is that a conclusion that you've reached?
No.
Is that not a conclusion that you've reached?
What the premise, what it would be, let's take away the validity challenge. And if you had
I'm asking you a question. Let's go, move away. We'll go away, okay, and we'll come back, because I think I think we're missing each other. So I'll withdraw the question. You've read ordinance 127.
I have.
You read the ordinance that existed prior to 127, correct? You read the zoning ordinance?
125, yes.
Well, 125 was an ordinance that was enacted a couple of years ago, but the zoning ordinance has been in place and gone through a series of amendments previously. You have that big fixed document there that's entitled zoning, chapter 175 zoning.
Yes.
Okay. You've read this?
Yes.
And you, in reading this, you read it with an eye towards, because 127 hasn't been codified into this, correct? This is Joint Exhibit 1.
Yes.
So in looking at Joint Exhibit 1, you can see what zoning looked like in the township prior to 175, I'm sorry, 127.
Yes.
I'm a little dyslexic. 127,
Yes.
and invert my 2s and 5s. What 127 created, correct? And is it your opinion, sir, not what Mr. Fode's opinion, but is it your opinion that the ordinance, the zoning ordinance prior to 127 allowed gas drilling everywhere? Is that your professional opinion, yes or no?
That's the ultimate opinion. What I testified to is that Mr. Fode was on solid legal ground in making that determination.
I'm asking you your opinion, sir.
I believe that mineral removal does not include oil gas operations. I also believe that the special exception provision for similar uses would not include, that determination is a reasonable determination that it's not.
I'm asking you a different question, sir. I'm not asking you to opine on whether Mr. Fode came to a reasonable determination. You are here as an expert witness. You've been proffered as an expert witness for your opinion. And I'm asking you your opinion. Did you conclude that oil and gas development was permitted by right under the zoning ordinance prior to 127?
I concluded that were I representing somebody in the industry, that I would have a compelling argument that it was not permitted anywhere in the municipality and that I had the right to do it in any district.
Are you here simply to offer opinions on what compelling arguments can be made or compelling arguments can't be made? Or are you also offering your own opinion as a zoning expert?
I'm offering my expert opinion on the application of these, not on the outcomes, not on the ultimate conclusion. And you're asking me for the ultimate conclusion of what would be found. And what I'm saying is I would.
If you were defending the township, you could make a compelling argument, couldn't you, that oil and gas development was included, was included in the definition of mineral removal.
Correct. It calls for speculation.
Overruled, go ahead.
You could certainly make that argument.
And you could also make the argument, couldn't you, that and if you did that, that would allow it in certain districts, correct?
That's correct. As special exception, I believe.
We can look at the zoning ordinance, we can look at the map, whatever districts mineral removal is allowed in, and that was what Professor Daniels found, right? That's how he came to that 30%, correct?
No, he said that it would be. He
Right.
made a legal conclusion.
He made a conclusion.
Yeah.
And you're simply saying that a municipal solicitor could argue that.
That's right.
And you also agree that there's a valid argument to be made, or at least a compelling argument, let me say that, that mineral removal, that oil and gas development is comparable to other uses that are allowed in the township, correct?
That's not exactly how that definition reads. If it read like that, you'd have a more compelling argument. That's a liberal paraphrasing of that.
Well, let's go back to the principle that we identified earlier. When there's a tie, it goes to the runner, it goes to the landowner, correct?
Yeah, and there's another, it also that there's an abhorrence to finding an ordinance unconstitutional, invalid. Yes.
And in fact, if you were representing EQT in front of the township, and you wanted to argue that gas development was prohibited, because it wasn't allowed anywhere, right? Isn't that true that the ordinance says, and it's a generally recognized principle in zoning, that unless it's allowed, it's prohibited, correct? Unless the ordinance identifies it as a permitted use, it's not a permitted use, correct?
Yes.
So rather than saying it's allowed everywhere, really what you'd be saying, if you were to read gas development out of mineral removal, you'd really be saying that it's prohibited everywhere, correct? If that was the
That's right.
And as a developer representing industry, if you wanted to then be able to do it anywhere, you'd have to bring a validity challenge, correct?
No. If the municipality would do what I think would be the proper thing, their zoning administrator would approve the permit.
Without changing the zoning and without a validity challenge being brought.
If I really believed that it was not provided for anywhere and there was not a legitimate consideration, a treatment, or permission of a legitimate land use, yes, I would say it's permitted.
You would first argue that it should be read to allow it, correct?
Yes.
And you would give that tie goes to the runner rule, and you would argue that, correct?
Yes.
And you would look, if you could, to the comparable use language that's in the ordinance, and if you could, you would argue that, correct?
You would. You'd latch on to anything you could if you were going to defend that.
And
With the with the knowledge that once you did that, and there's a finding, then you definitely don't have control.
well, then you got to bring a validity challenge.
That's right.
Okay. And then if you bring a validity challenge, you go through the same kind of process we're going through here, and you hope for the best, correct?
Well, were it that simple, and it's only zoning, but what was compelling in this, and it was
the process. I'm asking you a process.
I know,
question.
but
If you got a denial from the zoning officer, you've got to bring a validity challenge, correct?
that might not be the only way I go.
But
I
that's
might
one-
go a mandamus. I may go for a civil rights action if I thought they were discriminating.
You would bring some sort of legal challenge.
I would definitely recommend to the client that they do.
Yeah. Now, the ordinance has this provision that deals with comparable uses, correct?
Yes.